Hi CA final students. So the $1 million question in your mind is how to get exemption. So this video is about law, CA final law, corporate and allied law. So corporate law is 70 marks and allied law is 30 marks. So our aim is to get exemption. That means we should score more than 60 marks in both corporate and allied laws put together. So corporate law 70 marks, we should get somewhere around 50 plus, and allied law 30 marks, we should get out of that, we should get at least 15 plus, so that our criteria will be completed. Now the corporate law portion, now for November 17 onwards, it is 2013 only. There is no more 1996 Act except only one chapter, which is producer company. That also the Companies Act 2013 incorporated, but the same logic, the same section only, but it is incorporated in the Companies Act 2013. So you should study only Companies Act 2013 from November 17 exam onwards. For allied laws will come later. Now in your exam paper, the choice, including the choice, the total mark is 120. So it should be somewhere around 84 and 36. 84 is for corporate law and 36 is for allied law. Now we should go to the content. I will tell you how much mark each chapter is having the weightage and how to score. See, the first chapter in your syllabus is dividend chapter from the corporate law. So section 123 to section 127 is dividend chapter. Now this is also you have in your IPC auditing also. So 123 to 127 you are having in the dividend chapter. It is very easy to score in the dividend chapter because it is declaration of dividend and dividend rules and unpaid dividend and punishment for non-payment of dividend. This only you should study. Then after the dividend chapter, you have the books of accounts chapter. The books of accounts will start from 128 and it's going to be ended in 138. Okay. Now it has how to maintain the books of accounts, where to maintain, then financial statements. Then the new two section has been introduced: voluntary revision of voluntary revision of financial statement and tribunal revision of financial statement. So this two sections is going to be tested from November 17 exam onwards. So voluntary revision and compulsory revision by tribunal. Then afterwards you have that board report. Okay. Then you have accounting standards. Okay. In that also you have two things. One is as per section 133 you have to follow central government accounting standards. But 133 also says till central government accounting standard, that is Ind AS becomes mandatory, you should follow the old, that is NACAS accounting standard also. So those areas can be tested in the following examinations. Then you will be having CSR, corporate social responsibility, then circulation of financial statement and filing the financial statement with ROC. And that last one, that 138 section is internal audit. This is also you studied somewhere in the IPC, also in your auditing syllabus. So the dividend section will be approximately 5 marks. Okay, dividend chapter generally it will be 5 marks, and books of accounts 5 marks. So this they will become maximum, they will be coming in your 10 marks put together, it will come 10 marks in your paper. Then audit and auditors. See, nowadays our examiner is not touching audit and auditors in the law paper because you have auditing paper separately, no? In that they are touching the audit and auditors subject. Now audit and auditors starts from 139 and it ends in section 148. Okay. So it talks about appointment of auditors, removal, resignation, okay, remuneration of auditor, what is the powers and duties of the auditor, what they should be doing, what they should not do, restrictions on auditors, etc. And cost audit is also been included here. Then we will be going. So the audit and auditor chapter, you can touch and go, but anyway you are studying in auditing chapter, so you will not specifically study for law chapter. Yes, but it may come in the exam, in future exam, but it is not so much of weightage according to me is concerned. Now, we will go to the next chapter, that is a very important chapter, directors chapter. Now the directors is starting from section 149, okay, and ends in section 172. 149 to 172 is the directors chapter. Now in this directors chapter we will be seeing appointment of directors, okay, then different types of directors, small shareholder director, additional director, alternate director, okay, then woman director, resident director, everything we will be studying in this chapter. Then this director chapter has a more weightage, that is 12 marks weightage. They will be asking somewhere around 12 marks in this chapter. So this is very important. After that director chapter we have something called meeting chapter, that is board powers and meetings. 173 it starts and it ends in section 195. So board meetings, powers and boards, okay, powers of the boards, what they can do, what they cannot do, whenever they can get approval from, means like wherever they should get approval from the general meeting, ordinary resolution, special resolution, then whether they can contribute to political parties, those things. And we have related party transaction, that is one of the biggest section. and director disclosure of interest, those things will be handled. And the last two provision is insider trading and derivative transaction, those things will be handled. So this chapter is more weightage, according to me it should be somewhere around 12 to 15 marks weightage, this chapter alone. Then the third, it's continuation of the directors only. There is directors, we can say three parts. One is qualification and appointment of directors, and second one meeting powers of board, and third one we can say managerial remuneration and managerial personnel. So this managerial remuneration personnel starts from section 196 and ends in section 205. Here they are talking about MD, whole time director, and the key managerial person, what is the remuneration they can earn, schedule 5, etc. Now we will go to the next chapter. So this managerial remuneration chapter, somewhere around 8 to 10 marks they are touching. So this put together, these three topics, somewhere around 35 marks to 40 marks they are touching. This directors, meetings and managerial remuneration put together, somewhere around 35 to 40 marks they are touching. So this is very important chapter. Then after this we are going to inspection and investigation chapter. Section 206 it's starting, section 229 it's ending. So section 206 to 229, okay, it's inspection investigation chapter. So when central government will go for investigation, okay, when they will get the application, means like what is the petition, so what is the people, how many number of people has to file a petition, then when tribunal will send investigation, what is inspection, what is inquiry, what is investigation, what is the difference, and their penalty will be seeing here. This is 4 marks weightage chapter, 4 marks weightage chapter. Then we will be going to the next chapter, that is compromise and arrangement. Now this is a new topic which has been introduced in the Companies Act 2013. Compromise and arrangement section 230 to section 240. This is a new, totally new topic from November 17 and onwards. According to me, they should touch this topic. 4 marks is the minimum weightage for this topic. And here we will be telling mergers, amalgamation, arrangement with the creditor, either internal arrangement or external arrangement, okay. Then merger by central government, okay, amalgamation by the central government, then takeover, transfer of undertaking, all the things will be hiving of business, everything will be seen here. So this is a new topic, so you have to give more weightage here. Then after compromise and arrangement, prevention of oppression mismanagement. So this is from section 241 to 246. This has been introduced for May 17 exam and onwards. So mandatory for November 17 they are going to touch more marks here. So minimum 4 marks weightage here. So section 241 to 246, prevention of oppression and mismanagement. After that there is a new chapter has been introduced, removal of names. Okay, in case a dormant company, if they want to get their name removed, okay, it's not just winding up, it's winding up is a big process. Removal of name is a very simple process. Previously we called a striking of name. Okay, that is a new chapter introduced. Then after it's like up to 252 section up to 252 this removal of name section is there. Then after that we have from 270, okay, we have some 270 only, winding up starts. This is a very important chapter because it is totally new for November 17 examination. So this winding up, very carefully you should study, because previously we had voluntary as well as compulsory winding up. So I can say voluntary winding up by creditor, okay, voluntary winding up means by members, by creditors, and compulsory winding up by court. Previously we had. Now this two, that is the voluntary winding up by members and creditor, has been taken out to a separate act, that is called Bankruptcy and Insolvency Code 2016. So we will be seeing only the tribunals winding up. So in this we will be having section from section 270 to section 365, okay, but in between approximately 20 section has been removed from 304 to 325, that has been removed because it's all about that voluntary winding up and creditor filing up, those things has been removed. So approximately somewhere around 80 sections you have in winding up chapter. Then from 366, this is company capable of being registered under this act. See, winding up according to me 4 to 6 marks weightage. Winding up is 4 to 6 marks weightage, and removal of names as of now we don't find that questions in the exam, but it is there in the previous act also, but we don't find a big weightage on that. But winding up they are asking 4 to 6 marks they are asking. Then companies capable of being registered under this act, section 366 to section 378. Company, that is a firm, society, whether they can be converted into company. And this section also introduced a new 4th section has been introduced. This is striking of the name of the company, winding up of unregistered company, a new topic which has been introduced. Okay, striking off of unregistered company, winding up of unregistered company has been introduced very recently. 3-4 section has been introduced in that part. So 366 to 378 is incorporating a company which is previously a firm or a society or AOP, now become a company. That section. Till now they have not touched in this topic. So it's a B section. I can say it's a low weightage. Then foreign company, section 379 to section 393. That's a foreign company. In May 17 they have not touched anything. So I am sure in November 17 they are going to touch. Okay, 4 marks damn sure here. So foreign company. Then we have government company reports, 394 and 395. There are only 2 sections, government company reports. So in government company reports, 2 marks may come. It's not like every attempt it will come. One attempt it may come, one attempt it may not come. So just 2 sections, you can study that. Then 395 to 406. 395 to 404 is about ROC, registration, registered offices, they know about that. Then 405 is statistics and 406 is Nidhi company. See, Nidhi company is totally new concept, so you should study Nidhi company. Till now they have not asked. Actually it's expected question of May 17, but they have not asked. So maybe in November 17 they will ask the Nidhi company. And ROC generally 403, there is one section called 403, delay in filing of returns with ROC. That section is very important. Some 270 days they are giving extra. So according to me that 403 section in this chapter is important, that ROC chapter, and Nidhi company is important. Other than that I am not seeing more weightage. So put together I can see 2 to 3 marks weightage in this chapter. Then after that from 407 to 434 I have NCLT, that is National Company Law Tribunal and National Company Law Appellate Tribunal. This is a new chapter introduced for the exam May 17. So for November 17 also they are going to ask the question. In May 17 they asked some 4 marks question. This is regarding to the constitution of NCLT, they asked about technical members. See, NCLT, the next my prediction will be like appealing, they can ask, appealing, disposal of appeals, okay, disposal of application they can ask in the next examination. So section 407 to section 434 is NCLT and NCLAT, mandatory 4 marks will be asked from this area. Then section 435 to section 446 is a special court. Okay, special court has been introduced in the Companies Act 2013. Now the special court, some sections we also have in previous examination, even before May 17 we have, but from May 17 we have the 100% of this chapter. So before and all we have only one section from this, that is who can take cognizance of offence, what is non-cognizable offence, only this section will be there. But today's scenario the entire special court is applicable for our examination. So according to me they may touch 4 marks because May 17 they have not asked any question from special court. So in November 17 they may ask from special court 4 marks. Then we have offences and penalties, section 447, and to the end I can say 470 we have offences and penalties chapter, that is fraud, false statement, etc. From this we can expect minimum 4 marks. But this time they asked, that is May 17 they asked for approximately something around 8 marks they have asked, but 8 marks is too much for this chapter, we can expect somewhere around 4 marks. So this is what the weightage of Companies Act, that is corporate law I can say. And extra I told you one more topic, that is producer company. From 1996 they copy pasted. Producer company, it's we cannot predict how much marks it will come, because in May 16 examination it come for approximately 12 marks, but in May 17 it's 0. So we can say something around 4 marks here and an average. Okay, so 4 marks weightage we can give here. Then we will go to allied laws. So this is what our company laws portion I told you, approximately 70 marks portion. Now we come to allied law. In allied law we have SEBI. Okay, that is a high weightage chapter. 8 marks will be given for SEBI. So you cannot even ignore SEBI. In that SEBI, one question is from ICDR and another one is question from the basic SEBI. So SEBI has been divided into 2 parts. One is basic SEBI and another one is ICDR. So one 4 marks question from ICDR and one 4 mark question from basic SEBI. Then we have FEMA, that is Foreign Exchange Management Act, mandatory 4 mark question. Then we have SCRA, that is Securities Contract Regulation Act 1956. Here 4 to 6 marks they are giving mandatory. Here more definition they are testing. From SCRA mostly they are giving straight question and definition and penalty. Only these questions they are asking. In FEMA they are asking 2 types. One is export. Okay, FEMA export rules is there. So either they can ask from basic FEMA or FEMA adjudication or from export rules. Only from these topic. Or they can ask from one more topic, that is capital and current account transaction. So this is the topic they are asking FEMA questions. So FEMA, SCRA and SEBI is over. Then we have Banking Regulation Act. Okay, Banking Regulation Act is very simple. Okay, every 2 attempts once 4 marks question is coming. Then we have SARFASE, Securitization and Asset Reconstruction, okay, Enforcing Security Interest Act they are asking. So this question, this is a latest amended act, because in 2015-16 so many amendments happened in SARFASE. So mandatory they are asking questions. In SARFASE, the next examination I am thinking definitions can be asked. Financial asset definition, reconstruction definition they can ask. So definition can be asked in SARFASE, or they can tell what are the assets are exempted from SARFASE. That question may be very important. Then we have Prevention of Money Laundering Act. In that basically we have 3 schedules which has been now converted into 2 schedules only, A and C. In that that penalty will be there. Okay, what are the offence covered, what is the penalty, and what is the duties of the bankers. These questions only they can be testing, and what is the adjudication proceedings. So this is also 4 marks weightage. Then we have Competition Act. Every time Competition Act is tested for 4 marks. So mandatory you should go for Competition Act 4 marks. Then we have Insurance, IRDA and Interpretation. These are 3 topics we have. Insurance, IRDA. See, May 17 they have not touched insurance, 0. That is 0 they have touched. So according to me in November 17 insurance is a mandatory question. But IRDA for past 8 examination they are not asking IRDA. So according to me, if you want to leave choice, you can leave choice of IRDA, but insurance you should study. Then interpretation of statute, mandatory. So in interpretation of statute we have 2 rules, that is primary rules of interpretation, secondary rules of interpretation. So and we have aids of interpretation, internal external aids of interpretation. This 4 topic if you study you will score mark. So according to me this is what they are going to test, and this is the weightage they are going to have. Okay, see, nowadays the examination they are not giving allied laws separately. Every question has allied laws. So you cannot leave any of the allied laws. People have some itch in their mind that whether can they leave allied laws and go. Sir, please tell me what allied laws I can leave and go. According to me, I can hear only one thing, IRDA you can leave and go. That is what I can say. So, but any of the allied laws you cannot leave, because allied laws has been mixed with the director chapter. So one question will be director chapter, question A, B, C will be there. One director chapter will be there, yes I know. Then one books will be there, yes I know. But other question will be some SEBI, SCRA will be introduced. So if you leave allied laws portion aside, you may not answer that question. So all the best, you should do the entire portion, and if you study with this blueprint you can score exemption.